Mr. Chairman. By way of introduction, what I'm going to do is to update the core participants, or CPs, as to the work of the inquiry so far, and to indicate the more pressing issues facing us all, so that we can together move ahead as speedily as possible with the important work before us. I start with representation. Present today, excluding me and the inquiry legal team here, are some 23 counsel and solicitor teams representing a large number of core participants, or groups of core participants. Some CPs are present but have not put in written submissions and do not wish to address you. Some CPs are both present and have put in written submissions but do not wish to address you, and some CPs are neither present nor have put in any written submissions. There may be CPs who are not legally represented but who are here today, but we have had no indication that they would wish to address you. All CPs should have an updated speaking list. There are some late additions to it for further resident and bereaved CPs and for the Fire Officers Association. That speaking list is only for this procedural hearing. It establishes no precedent. The reason we have the MPS, the Metropolitan Police Services, as the first CP to speak is so that they can provide a brief update on the criminal investigation. The CPs will then speak in two successive groups. First, those representing the survivors, the residents and the bereaved families, who we suggest should speak in alphabetical order according to solicitor firm names. And second, the CPs who are organisations or government departments. In terms of total numbers of CPs in this inquiry to date, we have some 424 out of a total to date of 554 applicants for CP status. Those currently with CP status are 60 from families of the deceased, 193 who were Grenfell Tower residents, 4 leaseholders, 124 from the walkways, 1 survivor who was neither a resident of the tower nor of the walkways, and 26 CPs who are organisations, including the TMO, the Council, and the Metropolitan Police Services, and various government departments. There has been one application which is deferred, and we have had indications in the written submissions that further persons will be applying for CP status. The position as regards CPs is therefore still a little in flux. We will publish a list of CPs in due course, but with the interests of the survivors and the bereaved in mind, we do not intend to do so without hearing submissions from them. In addition to the documents on the inquiry's website, all CPs present here today have had the following documents: our Council's statement, dated the 15th of November, the provisional programme, an accompanying letter, dated the 15th of November, about this procedural hearing, a copy of the instructions given by the inquiry to our 7 experts, and all the other CP submissions, save where any CP has wished to remain anonymous. What I propose to do, Mr. Chairman, is first to introduce the issues briefly for Phase 1. I will then move to a consideration of witness evidence for Phase 1. I'll then say a little bit about the role of the inquiry experts at Phase 1 and our thoughts on timing, and I'll then finish with some points on the document disclosure process. We'll then move on to hear various applications by CPs following the speaking order in the list, and I'll then respond at the end to the specific applications before the inquiry and then wrap up. In this opening address, I don't propose to provide answers to all the many points made in the CP's written submissions. Instead, we will wait to hear what further points are made to you, Mr. Chairman, by the CPs during the next 2 days. So I can turn to issues for Phase 1. The focus of Phase 1 will be the events of the night of the 14th of June 2017, and in particular, the existing fire safety and prevention measures at Grenfell Tower, where and how the fire started, the development of the fire and smoke, how the fire and smoke spread from its original seat or starting place to other parts of the building, the chain of events before the decision was made that there was no further savable life in the building, and the evacuation of the residents. Phase 1 will also examine what the emergency services did by way of response and when. As we have said in the Council's statement, the aim is that Phase 1 is a purely fact-finding exercise. That is because the logical place to start is to find out what happened and how it happened, before moving to why it happened and what could be done to stop it happening again. Those issues are issues in the list of issues corresponding to paragraphs 11A and B and 12A, B and D, plus, so far as relevant, the issues at paragraphs 1A, 4B and 5A and I. All other questions contained in the terms of reference and expanded upon in the list of issues will be considered in Phase 2. Now, the FBU, the Fire Brigades Union, has suggested a slight expansion of these primary factual issues, and the LFEPA, in other words, the London Fire Brigade, has also suggested some clarification that matters such as policy and training be included at Phase 1 so as to provide some context around firefighter actions on the night. Other CPs have suggested expansion of Phase 1 to cover specific further issues, and many have expressed doubt that there is any workable division between Phase 1 and 2. What issues are or should be added to Phase 1 should be approached with an open mind, provided that we all stick to the basic principle that it must be an investigation of the facts as they occurred on the night of the fire and into the next day, and provided that it is done as swiftly as possible so as to enable you to report on that question by the autumn of 2018. The fire at Grenfell Tower, Mr. Chairman, has provoked widespread public concerns about fire safety in tower blocks, both in Britain and internationally, and those concerns must be addressed urgently. The answers to the Phase 1 issues will not necessarily provide all the answers on public safety, but they will go a long way to providing a measure of clarity and may enable urgent recommendations to be made at an interim stage. In addition, and perhaps most importantly, this inquiry does need to be conducted promptly. The need for promptness is strongly supported today by the submissions of many of the CPs, including the Mayor, Mr. Sadiq Khan, and that applies to both phases of this inquiry. I then turn now to the witness evidence at Phase 1. The basic underlying logic of our provisional programme at Phase 1 is that the Phase 1 factual witness evidence, both written and oral, will come from three sources. First, the Grenfell Tower residents, in other words, the survivor residents of the tower, residents of the walkways, and the bereaved families of those who were lost in the tower. Second, firefighters, including incident commanders and certain control room staff. And third, experts called by the inquiry. I'm going to come back to the question of experts in due course. I just want to focus for the moment, if I may, on the Phase 1 factual witness statements. As to the Grenfell Tower survivors, residents and the bereaved, it is of great importance to the inquiry that each individual voice of those most affected by the fire is heard. This was a shared trauma, a community devastated. But each of them has their own story to tell. Their evidence will be crucial to the inquiry's understanding of what happened inside and around Grenfell Tower before the fire, during the fire, and after the fire. Their evidence can and will help us to save the lives of others. Giving that evidence is also one aspect of the way in which each of them individually can be heard and perhaps find some measure of closure. The fire at Grenfell Tower was an utterly appalling event, and the experiences of it are stamped on the lives of the many to whom Grenfell Tower was home, and of the families of those who were lost, and each in so many different ways. As individuals, they may each have a different wish and a different view as to how they individually can assist and join in the work of the inquiry, and how the inquiry can assist them give their evidence. We do understand that many of them have other immediate issues which are far more pressing than assisting this inquiry. We also recognise that being asked to relive the events of the night, to prepare a statement for the inquiry, will, for many of them, be difficult and traumatic. And the process of giving oral evidence to the inquiry equally, if not more, challenging. But we must also try to move promptly and effectively with the aim of learning lessons from this awful event in order to save the lives of others and in order to ensure that something like this can never happen again. That in turn means that we must work towards producing a Phase 1 report by the autumn of next year in order to start to address those urgent public safety issues. As to the witness statements which we would like the survivors, residents and bereaved to give us for Phase 1, we envisage that these will be taken by their respective solicitors and will be prepared with the benefit of their individual police statements and exhibits where they have given them, and any 999 calls relevant to them, and any photographs or videos that they made. In essence, a witness pack, one for each. There are strict security arrangements as to the use of any material coming from the police investigation. Those are governed by our Memorandum of Understanding with the police. It's for the inquiry team to provide these witness packages to them, subject to the Memorandum of Understanding. The statements that they made to the police, which are given to their solicitors, must be sent back to the police by the inquiry once their statements are signed. There are some who are willing to provide their Phase 1 statements to us within some 6 to 8 weeks or so after receipt of this basic Phase 1 information. We warmly welcome that approach. That would at least allow the inquiry to feed their vital written evidence and experiences about what happened on the night of the fire into the inquiry experts' work on Phase 1 and the opening statements for counsel to the survivors, residents and bereaved, so as to ensure that the Phase 1 expert conclusions and your report, Mr. Chairman, on the Phase 1 issues are as comprehensively evidence-based as possible. Some of their solicitors have requested disclosure of their housing files in order to start work. We're not clear at the moment what will be in those files that would be relevant to the Phase 1 issues, and so we would welcome clarification on that. There are also some who may not wish to provide any statement to the inquiry until they have all the Phase 1 and Phase 2 disclosure, or who would only wish to give evidence to the inquiry at Phase 2 and in one go. We would ask that they help the inquiry to work effectively by agreeing to provide us anyway with their standalone Phase 1 written statements based on their own individual preliminary evidence packs. However, if they do not wish to give oral evidence more than once, then we will only call them to do so at Phase 2, even if that means hearing further Phase 1 evidence. We would therefore invite their solicitors to consider these issues further as soon as possible, and then to inform the inquiry how they would wish to proceed. The inquiry wrote to the numerous solicitors for these CPs on the 7th of November, asking them to identify each survivor, resident or bereaved client who was able and willing to give evidence about the events of the 14th of June, and whether they had provided statements to the police. Some solicitors have indicated that they are willing and able to do so, but the numbers are as yet very small, and we would encourage them all to communicate with us on these issues as soon as possible and tell us which client is willing to provide statements for Phase 1. We wrote again on the 28th of November, reminding solicitors to provide us with that information and confirming advance funding with which to be able to provide it. We would also invite all those solicitors to sign and return the undertakings that we've sent them so that the police material can be provided to them. I would also repeat what we've said in the Council's statement, that the written witness evidence from survivors, residents and the bereaved on the subject of the personal impact of the fire on them will, if they so wish, form part of the formal inquiry record come what may, and regardless of whether they have any other evidence of relevance and whether or not they are called to give oral evidence. Each personal experience is as important as the next, and each statement about it will be treated in the same way, so as to form an enduring written testimony. There will in due course be further correspondence or announcements about how the inquiry will take any evidence from vulnerable witnesses, including children. We would welcome further dialogue with solicitors about this subject over the forthcoming weeks in order to identify at an early stage those who may fall into this category. There are a very small number of resident CPs who are currently without legal representation. It would be helpful to the work of the inquiry if those persons would instruct one of the firms of solicitors currently acting for the CP residents, survivors and the bereaved also to act for them. To the extent that they do not wish to be represented but do wish to make a statement, then they are strongly encouraged to contact the solicitor to the inquiry and she will make the necessary arrangements. I turn to firefighters. The witness statements of those members of the London Fire Brigade who fought the fire on the night and the following day and were in command of the firefighting responses are being taken by the police in close liaison with the London Fire Brigade and the Fire Brigades Union, the FBU. The inquiry expects that interviews with some 250 or so firefighters will have been completed by Christmas and that the totality of the signed firefighter statements will have been provided to the inquiry team by the end of January 2018. We have already received more than 40. So far as the provisional programme is concerned, I'm not proposing to go through that in detail at this stage. Clearly, some of the detail in it will need to be revisited in the light of the submissions that we have received for this hearing and which, Mr. Chairman, will be developed orally before you over the next 2 days. We do hope to be in a position to publish a more detailed timetable in January before a further procedural hearing, which we would anticipate holding towards the end of January 2018. So I turn next to the question of experts to the inquiry. I'm going to provide an update on the work of the experts who have currently been instructed. As you, Mr. Chairman, explained in your opening statement, many of the questions which have to be answered in this inquiry are of a highly technical nature. To that end, the inquiry has instructed a number of respected experts, including in the field of fire forensic analysis and fire engineering, to assist the inquiry by examining the evidence and producing expert reports. The identities of those experts were published on the 12th of October 2017. More recently, and in response to requests from core participants to do so, the inquiry published its letters of instruction to each expert. Some of the experts have been asked to produce a Phase 1 report, as well as a Phase 2 report, and others will not be reporting until Phase 2. I would like briefly to identify those experts and expand on the areas that they've been asked to address. First, Professor Niamh Nic Dade. She is a professor at the University of Dundee and is an expert in forensic science and fire scene investigation. She has been instructed to advise on the cause and spread of the fire in the flat of origin and the spread of fire within and out of that compartment. She will be producing a report at Phase 1 only. Next, there is Professor Luke Bisbee. He is a professor at the University of Edinburgh Engineering Department. He is a structural engineer and an expert in fire structures. He has been instructed to opine on the ignition of the facade materials, including the cladding and insulation, and the fire spread over the building's external facade. Those issues will be addressed in a Phase 1 report. At Phase 2, he will also report in further detail on the performance of the materials which form part of the external envelope and the contribution to the spread of the fire, together with any issues relating to the mechanical response of the concrete structure of the building. Next, there is Professor Barbara Lane. She is a chartered fire engineer and a UK leader for the Applied Innovation and Technology Group at Arup, a large firm of engineering consultants. At Phase 1, she will be producing a report which addresses the active and passive fire protection measures within the building and the extent to which they failed to control the spread of fire and smoke and contributed to the speed at which the fire spread. At Phase 2, she will be giving an opinion on the design and construction of the building, whether regulations, legislation, guidance and industry practice were complied with, and the fire safety measures adopted in relation to it. Next, Steve McGurk. He is a former Chief Fire Officer who previously led 3 of the country's largest fire and rescue services, Cheshire, South Yorkshire and Greater Manchester, in a career which spanned 39 years in the fire service. He will be producing a Phase 2 report which will focus on the adequacy of the London Fire Brigade inspections and risk assessments and procedures and training for high-rise buildings. He will also be looking at the adequacy of the London Fire Brigade's response on the night and also the adequacy of the response to similar incidents, including the Lakanal House fire. Next, there is Colin Todd. He is an expert in fire safety legislation and runs a consultancy in fire risk assessment. At Phase 1, he will be producing a report which sets out the different statutory and regulatory requirements in force over the lifetime of this building, i.e. since the early 1970s to the present day. He will also explain how the needs of vulnerable persons must be considered and met in accordance with the relevant statutory duties. At Phase 2, he will consider the adequacy of risk assessments in relation to Grenfell Tower and the extent to which regulations, legislation, guidance and industry practice were complied with in the case of Grenfell Tower and fire safety measures adopted in relation to it. Next, we have Professor Edwin Galea. He is a professor and director of fire safety engineering at the University of Greenwich. He is a fire engineer, but with particular expertise in human behaviour and evacuation. He will be producing a report at Phase 2, which will involve and include various computer modelling, including a fire and smoke modelling and fatality and evacuation model. That modelling will then assist in answering various questions about the fire, including the contribution of the design and construction of the building to the fire and smoke spread, and factors which may have influenced those things. Finally, there is Professor Jose Terrero. He is a professor of fire protection engineering at the University of Maryland in the US. He will be reporting on the forensic fire spread throughout the building at Phase 1 of the inquiry's work. At Phase 2, he will be looking at the correlation between the fire safety provisions and strategy for Grenfell Tower and the adequacy of the London Fire Brigade procedures for dealing with fires in high-rise blocks. He will also provide an overview of conclusions to be drawn about the fire, including lessons to be learnt in the context of other fires, both internationally and domestically. In the submissions which you have received for this hearing, Mr. Chairman, the question of expert evidence has been raised by a number of core participants. Prior to hearing any further oral submissions which CPs may wish to make on this subject, it may assist you if I make the following points, and there are 7 of them. First, It is the case that careful conflict checks were carried out in relation to all experts before they were instructed. As Inquiry Counsel, we are satisfied that none of our experts is conflicted, and we will ensure that their written reports to the inquiry contain appropriate declarations to that effect when they are produced. That includes the most recent inquiries raised by the Fire Brigades Union about Mr McGurk and Ms Redfern, to whom we have put those concerns and have received full and satisfactory responses. Although it's correct that they know each other professionally, the inquiry team has no concerns that they will not be able to discharge their respective roles as expert and as assessor, respectively, to the highest standards of independence and integrity. Secondly, we recognise that core participants have not had long to digest the instruction letters to experts which were circulated on the 30th of November. We would welcome any observations that CPs may have on those instructions, which can be made in writing after this hearing if that is convenient. The inquiry has been asked to provide the CVs of these experts in due course, and this seems to the inquiry team to be a sensible suggestion which we will take forward so as to ensure that those CVs are circulated as soon as possible. They would be attached to the written experts' reports in any event. Thirdly, as Inquiry Counsel, we recognise that there are other areas of expertise where expert evidence may be necessary. This remains an ongoing issue which is being actively considered as the expert evidence develops, and if and when it becomes apparent that other areas of expertise are required. It appears highly likely that there will be a need for other experts at Phase 2, and we will keep that under review as the inquisitorial process unfolds. Fourth, a number of concerns have been raised about the precise cut-off point between the expert evidence in Phase 1 and in Phase 2. For example, questions have been raised about whether it is necessary to have any qualitative assessment of the active and passive fire safety measures within the building at Phase 1, and as part of a consideration of whether they failed to control the spread of fire and smoke. Whilst it's right that the principal focus of Phase 1 is about establishing the factual events of the night, our submission is that it is necessary at this early stage to understand how those active and passive measures performed, not least given the need to report on matters affecting public safety in the interim report after Phase 1 has concluded by way of evidence. There is also a need to ensure that any conclusions about fire spread at Phase 1 are appropriately informed by an understanding of the fire safety measures and issues which are actually present in the building. Fifthly, a number of core participants have raised the possibility that they may wish in due course to apply to instruct their own experts, and they note that the current provisional timetable in the provisional programme does not allow sufficient time to digest the inquiry experts' reports and make any such applications. We are sympathetic to that, and we do recognise that core participants may need longer to digest the reports and make any such applications. We suggest that this be taken into account when it comes to setting down the directions in the lead-up to the commencement of the Phase 1 hearings. This is not, I should say, an invitation to apply. Core participants will be expected to make out why they should be treated exceptionally. Sixthly, a number of core participants have raised the question of whether their experts may have access to the site. As to that, the site remains a crime scene, and as a result, any access is strictly controlled by the police. We understand that the police's position is that access generally for core participant experts cannot occur while the site remains a crime scene, and that access in the future will be a question for the owners of the building to determine once the site is handed back to them by the police. In order to mitigate the lack of access at the present time, we have asked our inquiry experts to keep a careful eye and record of their visits to the tower, which will form part of their reports and which will hopefully assist other experts when it comes to considering their work. We will also continue to encourage the police and the owners of the building in due course to permit access to the site at a time when that is considered compatible with the criminal investigation, and assuming that such access can be safely facilitated given the condition of the building. Seventhly and finally, I would reassure all core participants that all evidence relied upon by the inquiry experts will be appropriately annexed and cross-referred to in the inquiry expert reports, so that the evidential basis for those reports is absolutely clear, objectively verifiable and readily digestible. So now I turn to the question of disclosure. A number of core participants have asked questions about the inquiry's processes for obtaining documents and onward disclosure to core participants. I provided an update on disclosure in my council statement on the 15th of November, at paragraphs 11 to 13. In that statement, I said that we would provide further details about how the mechanics of disclosure would work in due course. And I understand that, and I know that some core participants want further clarity now, and I'm very happy to provide that. It's important to note at the outset that the process of obtaining relevant documents started immediately after the inquiry set-up date in August this year. It remains ongoing. A large number of document request letters requesting all documents relevant to the inquiry's terms of reference were sent out within the first few weeks of the establishment of the inquiry. Relevance is defined in paragraph 3 of the document protocol as, quotes, those which, having regard to the inquiry's terms of reference, it is likely that the inquiry panel would, if aware of their existence, wish to be provided with, close quotes. As explained in the protocol at paragraph 10, providers are required to undertake, quotes, comprehensive, thorough and rigorous searches in response to a request for documents, close quote. Now, in order to help document providers, the inquiry also identified specific categories of document which the inquiry expected would be included in such disclosure. Those letters were sent to a wide range of persons and organisations. Many of those requests resulted in very significant numbers of documents being provided to the inquiry. The inquiry has currently gathered approximately 231,000 documents from some 33 document providers, i.e. an additional 31,000 documents since our council statement in mid-November. That number continues to increase week on week as we identify more document providers and ask existing document providers for more documents. Such document providers are giving us rolling disclosure. We estimate that there may be at least another 40,000 documents to come. We will say we will probably have some 270,000 documents in all. That does not include the Phase 1 999 calls and pictorial material which we will have obtained from the police. To date, the solicitor to the inquiry has requested documents from a wide range of providers, as I say, including those responsible for Grenfell Tower, public authorities, the emergency services, designers, contractors, suppliers, and manufacturers. If at any stage it comes to light that further requests for information or documents need to be made, then that is actioned swiftly by the inquiry team. There have been occasions where further information has come to light about who may have had a role to play in the matters that the inquiry is investigating, and as that information has become available, the solicitor to the inquiry has made document requests of other organisations and persons. The inquiry has devoted a considerable amount of resource to the disclosure exercise. Once documents have been obtained, the inquiry has in place a large team of paralegals and junior barristers who are responsible for reviewing the documents for relevance and for categorising the documents in a way which reflects the inquiry's list of issues. That work is supervised by an experienced barrister and in turn closely monitored by counsel to the inquiry. At the moment, our review rate is about 12,000 documents per week. We estimate that that will rise in January to about 20,000 documents per week as we bring on stream more barristers and more paralegals to the review teams. Core participants have asked what processes the inquiry has in place to ensure that providers have not been selective and that all relevant documents have been disclosed. The processes are as follows. Each provider has been asked to provide a signed inventory of documents. That's required at paragraph 13 of the documents protocol. If appropriate, the inquiry has requested a witness statement from the provider setting out details of how the documents were originally stored, search terms used, or other processes used to locate documents, and the nature of any review carried out by the document provider. Where the inquiry has any queries or concerns about a provider's processes for locating relevant documents, it has raised them and pursued them. As documents have been reviewed and gaps have been identified, further documents have been sought. To the extent that it has been necessary for the inquiry to see documents in the format in which they were originally stored or organised, we have requested copies in that format. This process will continue throughout the inquiry's investigation. Some have also asked whether the inquiry has taken steps to seize documents before they are destroyed. You, Mr. Chairman, do not have the power to seize documents. However, you do have the power to compel production of documents under Section 21 of the Inquiries Act. There are also provisions in Section 35 of the Inquiries Act which make it an offence if, during the course of an inquiry, a person does anything to alter or distort a relevant document or prevent any relevant document being produced to the inquiry, or intentionally destroys, suppresses or conceals a relevant document. At this stage, provision of documents has been voluntary and the inquiry has had considerable cooperation from document providers, but it has been made clear in the protocol that you will consider exercising your Section 21 powers in circumstances where a request is refused, incomplete or not provided by the stated deadline. In any event, the Metropolitan Police Service seized a very considerable number of documents in the days and weeks following the fire as part of its criminal investigation. If it becomes necessary to do so, the inquiry can request access to those documents from the police pursuant to the terms of the Memorandum of Understanding. Finally, a number of core participants have requested disclosure of all document requests and a full transparency over the inquiry's process for obtaining documents. We're sympathetic to the desire for core participants to understand the inquisitorial processes which are being adopted. We understand that at this early stage in the work of the inquiry and prior to the disclosure to core participants of relevant information, individuals are anxious to know what work has been taking place and to receive some reassurance that relevant documents are expeditiously being gathered. In that regard, I would make 3 points at this stage. First, as an inquiry team, we propose to give regular disclosure updates in which we can report on progress which has been made in obtaining relevant documents. We will also aim to do at any relevant procedural hearings, although we are happy to meet representatives of the core participants to explain in greater detail how that process is being progressed. Secondly, we would wish to emphasise that core participants will be receiving a large quantity of relevant material in due course once the inquiry has digested the material in raw form which it has received. We do not propose only to provide core participants with documents relevant to them. Everybody will receive the same documents. We will provide all documents that the inquiry has received, subject to 4 things. First, a relevance review, so that only relevant documents are provided. Second, a deduplication exercise. We have already identified very significant duplication in some of the documents which have been provided to us. Third, the Memorandum of Understanding with the police. And fourth, a form of redactions in accordance with the redactions protocol. A number of core participants have urged us to begin the process of Phase 1 disclosure as soon as possible, and to ensure that Phase 2 disclosure does not await the conclusion of Phase 1. Again, we are sympathetic to that, and we will try to ensure that disclosure of relevant material is disclosed as soon as possible, so that it can be digested by the core participants, or at least the process can start. We will also give further thought to the suggestion of rolling disclosure at logical points in the lifetime of the inquiry. Thirdly, it isn't, however, sensible or practicable to disclose every document request the inquiry has made, nor is it possible to disclose to core participants every document the inquiry has received. In terms of document requests, we've explained our processes in the documents protocol, and I have given details as to how we propose to put that protocol into practice. We are regularly going back to document providers with queries or further requests, and although we, as I say, very happy to provide regular updates on disclosure, it is not necessary or proportionate to disclose every single piece of correspondence or exchange on this subject, as that would impose a significant administrative burden on the inquiry, thereby distracting the inquiry from its inquisitorial work. In terms of disclosure to core participants, the inquiry has received a substantial number of documents that are irrelevant to its investigation on any view. It has also received a significant number of duplicates, and it would be costly and timing for core participants to work through irrelevant and duplicate documents. It would also place a further burden on the inquiry team, as the redactions process would need to be applied to all documents, not just relevant documents. In those circumstances, we would propose that the inquiry should provide all core participants with relevant documents in due course. Prior to that, we are very happy to receive suggestions from core participants about lines of inquiry which they think we should be pursuing if there is any concern that particular categories of document may not be being sought. We are also happy to meet with representatives of core participants so that we can discuss with them in detail any concerns that they may have about the gathering of relevant information and the disclosure that they will be receiving in due course. Core participants will also be in a good position once they receive the relevant documents for each phase of the inquiry to make further suggestions if they feel that there are any areas where further documents or information ought to be sought. To conclude, I've laid out where the inquiry stands at present in procedural terms, but we are here to listen to all core participants about how this inquiry should proceed, so that in our planning we can take careful account of what they say. Thank you very much.
Thank you very much, Mr. Millett. Now, Mr. Johnson, you're here for the Metropolitan Police Service, I believe. Would you like to say something now?